Yes, no panic.
Thank you, my lord. The substance of the justification argument, can I remind the board of the test, although I don't think there's any dispute between the parties on this appeal. It's section 8.5 at page 1382, and the board sees that what the appellant has to show is that the hindrance is, in the third line, reasonably required in the interests of defined interests A and B, and if the appellant can show that there is a reasonable requirement in those interests, then it is open to the claimants, us, the respondents, to show that it's not reasonably justifiable in a democratic society. And that final element, although the burden is shifted, overlaps very substantially indeed with the first two elements. That is, you've got to, the appellant has to identify essentially a legitimate aim, and that what has been done is reasonably required. But there are those three separate elements, and that appears from a number of cases, in particular the case of Worm, which is at page 5434, a Grenada case. Lord Roger speaking for the board, and the board will see at page 5445, it's a free speech case, and the relevant provision is at letters C to D, 5445, and it's in very similar form to section 8.5 of the Bermuda Constitution, and paragraph 41 on page 5458, Lord Roger explains what needs to be done in the third line. It is therefore necessary for the respondent, that's there the Commissioner of Police, to show that the provisions are reasonably required for the purpose of protecting the reputations, rights and freedoms of other persons. If that is established, the burden shifts to the appellants to show in terms of the last limb that the provisions are not reasonably justifiable. And that test is the de Freitas test in the previous paragraph. One, does the legislative objective, is it sufficiently important to justify limitations? Are the measures rationally connected? And are the means used no more than is necessary? A very familiar test. I also remind the board that Lord Bingham, for the appellate committee, explained in the Huang case, which is at page 2760. I could invite your lordships and ladyship just to turn that one up, 2760. Lord Bingham said that there is in fact a fourth limb to the de Freitas test. His lordship said that at page 2780 at paragraph 19, where his lordship set out the de Freitas test, 2780, paragraph 19. His lordship set out the de Freitas test, and then he said just under D, this formulation has been widely cited and applied, but counsel for the applicants with the support of liberty suggested the formulation was deficient in omitting reference to an overriding requirement which featured in another Canadian Supreme Court judgment of Chief Justice Dixon, from which this approach to proportionality derives. The feature is the need to balance the interests of society with those of interests and groups. This is indeed an aspect which should never be overlooked or discounted. So that's the test. As I say, there's a large degree of overlap between these various tests. We say, first of all, that the appellant has failed to establish that the revocation provisions do advance any of the specified legitimate aims in section 8(5)(a) or B. There is no general public interest defence. The appellant has to point to a legitimate aim, and the only one to which the appellant has drawn attention is protecting the rights and freedoms of other persons. That's at section 8(5)(b). But the appellant has not identified which of the rights and freedoms of others need protecting, or how those rights and freedoms would be protected, would be prejudiced were same-sex marriage to remain valid. Our case, and I've made this point already, but I repeat it, our case is that the rights and freedoms of others are in no way adversely affected by the right of same-sex couples to have a valid marriage. I showed the board the observations of Justice Sachs in the South African Constitutional Court making that point. Its authorities it's at page 3431, the particular passage of Justice Sachs's analysis in South Africa. And the same point was made in the judgment of Justice Kennedy for the United States Supreme Court in Obergefell, which appears at page 3672 in Justice Kennedy's judgment for the majority, 3672. On the left-hand side of the page, about a third of the way down, just under a third of the way down, there's a sentence: the respondents have not shown a foundation for the conclusion that allowing same-sex marriage will cause the harmful outcomes they describe. Indeed, with respect to this asserted basis for excluding same-sex couples from the right to marry, it is appropriate to observe these cases involve only the rights of two consenting adults whose marriages would pose no risk of harm to themselves or third parties. My Lord, Lord Reid referred to the dissenting judgment of Justice Scalia. Not sure whether that passage is one he had in mind when he said Justice Kennedy's opinion is couched in a style that is as pretentious as its content is egotistic. But that's what the majority had to say in relation to. Couldn't resist that, my Lord. I'm sorry.
No, it's a gift that keeps on giving. There are other passages where Justice Kennedy is quoted, and then he says, "Huh?" Just leaves it.
It is a most. I also liked page 3693, buried between the mummeries and straining to be memorable passages of the opinion. The striking feature, if I may just add to that, is that they were all very good friends, and there was no personal animosity whatsoever. Quite remarkable. Quite remarkable. But there we are. I also draw attention in relation to this question of legitimate aim to what was said in the Halpern case. The board will recollect that my friend relies on Halpern. I too rely on, and I've addressed my friend's reliance on Halpern. But if I could invite the board, please, to go back to Halpern's. It's page 2599, where the Ontario Court of Appeal addressed this question of legitimate aim. As I indicated, the main thrust of the judgment is finding in favour of the claimants who were seeking the validity of a same-sex marriage, and the court dealt with the question of purpose under the proportionality issue at 2599. It's at the bottom of the page, my lords and my lady, the last sub-paragraph. And what the court says is this: the court must be guided by the values and principles essential to a free and democratic society, which I believe, says his lordship, embody, to name but a few, respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions which enhance the participation of individuals and groups in society. The underlying values and principles of a free and democratic society are the genesis of the rights and freedoms guaranteed by the Charter, and the ultimate standard against which a limit on a right or freedom must be shown, despite its effect, to be reasonable and demonstrably justified. Accordingly, a purpose that demeans the dignity of same-sex couples is contrary to the values of a free and democratic society and cannot be considered to be pressing and substantial. A law cannot be justified on the very basis upon which it is being attacked. So for the Canadian Court of Appeal, the very aim on which my friend purports to rely is itself not a legitimate aim for the purpose of a proportionality analysis. And I do respectfully adopt that. I say that the wish, however sincere, of some people to live in a society in which others do not enjoy a right to marry because they are a same-sex couple is not, in my respectful submission, a legitimate aim. The second part of the analysis is whether or not there is a reasonable relationship between the objective, if it is legitimate, and the means which have been adopted in this context. And again, I say that it's the Halpin case assists on this, because the Attorney General also failed to satisfy a rational connection test. The relevant passage on that is at page 2601. At the bottom of the page, there's the heading Rational Connection. And over the page at 2602, paragraph 129, his lordship says that the difficulty with the Attorney General's submission is its focus. It's not disputed that marriage has been a stabilising and effective societal institution. The couples are not seeking to abolish the institution of marriage, they're seeking access to it. So the task of the attorney is not to show how marriage has benefited society as a whole, which we agree is self-evident, but to demonstrate that maintaining marriage as an exclusively heterosexual institution is rationally connected to the objectives of marriage, which in our view is not self-evident. And there's a bit of detail, and at the bottom of the page, 132, they conclude that the objectives are not rationally connected to the opposite sex requirement in the common law definition of marriage. There's simply no rational connection between the objectives of marriage, mutually understood, and excluding same-sex couples from them. And in any event, says the Court of Appeal, and we respectfully adopt their approach. There's no reasonable relationship here. The approach adopted is far from necessary, far from reasonably required. Yes, I'm grateful to my friend Mr. Achide Sterling for drawing my attention to, what was the page number?
Paragraph 134.
Yes, paragraph 134, page 2603. We reject the attorney's submission as speculative. The justification of a charter infringement requires cogent evidence, and that supports, I'm grateful, that supports the submission I was making before the short adjournment, that in this context, if you're going to attempt to justify, you need some evidence and not merely the submissions of counsel, however persuasive they may otherwise be. Then at 2604, paragraph 137, the court says allowing same-sex couples to choose their partners to celebrate their unions is not an adequate substitute for legal recognition. This is not a case of the government balancing the interests of competing groups. Allowing same-sex couples to marry does not result in a corresponding deprivation to opposite-sex couples, nor is this a case of balancing the rights of same-sex couples against the rights of religious groups who oppose same-sex marriage. Freedom of religion ensures that religious groups have the option of refusing to solemnize same-sex marriages. The equality guarantee, however, ensures that the beliefs and practices of various religious groups are not imposed on persons who do not share those views. In our view, the opposite sex requirement in the definition of marriage does not minimally impair the rights of the claimants. Same-sex couples have been completely excluded from a fundamental societal institution. Complete exclusion cannot constitute minimal impairment. And the conclusion at 141, since we've already concluded the objectives are not rationally connected and the means chosen do not impair the rights as minimally as possible, it's axiomatic that the deleterious effects of the exclusion of same-sex couples from marriage outweigh its objectives. So the court was very firm indeed on each and every one of the limbs of the de Freitas analysis or the Section 8.5 analysis, whichever way one wishes to look at it, that there is, in the view of the Canadian court, no justification at all. And I say that is right. I say that there can be no doubt that the denial of legal status for same-sex marriages damages intensely the dignity, the self-worth, the very status of a same-sex individual. It marks them out as excluded from one of the central societal institutions, with all the benefits that that institution confers, both for the individuals and for society, and of course for their children, because many same-sex couples have children, either children of the partners from former relationships or adopted children that they may have. And we therefore say that on one side of any balance, there is the strongest possible set of arguments, and on the other side of the balance there is the weakest possible arguments, because for all the reasons that the South African court gave, and all the reasons that Justice Kennedy gave, and all the reasons that this Canadian court gives, there is no question of any rights of religious groups being adversely affected. They are perfectly entitled to maintain the view, maintain their religious view, that same-sex marriage is anathema to their religious principles, and they, from their religious perspective, will not be involved in any such ceremony, and they will not recognize it in their faith, in their religion. And that's entirely, of course, a matter for them. Now, my friend Mr. Crowe emphasized at the end of his submissions the margin of discretion that he says should be accorded to the Bermuda government. Well, I entirely understand that submission as a general proposition, but it doesn't apply in this case. And there's a very good reason why it doesn't apply in this case. The whole notion of margin of discretion is based on the premise that the government, the respondent institution, will have conducted for itself the balancing exercise. It will have formed a view as to how the competing considerations of the interests of claimants and the interests of respondents, of other groups in society, need to be balanced. The difficulty here for my friend, I say insuperable difficulty with respect, is that the evidence shows, and I took the board to it before the short adjournment, that the appellant proceeded on the clearest possible basis that there was no interference with constitutional rights at all. The appellant's position was that there is no prima facie breach of freedom of religion, of freedom of conscience. That was her view, and it's set out in Miss Azar's affirmation, which I took the board to before the lunch adjournment. So she, the appellant, on behalf of the government, has at no stage conducted a balancing exercise that accords with the constitutional requirements. On the contrary, she has proceeded on, assuming that the board accepts my earlier argument, otherwise justification is irrelevant. But on the basis of my earlier submission, she has wrongly proceeded, with all due respect, on the assumption that there is nothing to be balanced. There is only a claim that raises no prima facie interests of freedom of conscience or freedom of religion. Indeed, she's also wrongly proceeded, if I may say so, on the basis that all that this case is concerned about is a label. And I've dealt with that already as to why that fundamentally misunderstands the importance of the respondents' interests, which need to be balanced. So I say that when the board asks itself at this stage, to what extent is it appropriate for the board to recognise a margin of discretion, I say nil discretion, because the board is not in the position of the respondent, as is normally the case, having itself conducted an analysis that accords with basic constitutional principles. On the contrary, the government has, on our submissions, fundamentally misunderstood the nature of the exercise. Nor, in my submission, can Mr. Crowe rely on the legislature having conducted any balancing exercise that confers a margin of discretion for the purpose of a proportionality exercise. The legislature did not say that we need to address the constitutional prima facie rights of the then claimants, here the respondents, and we need to ask the question whether or not in constitutional terms there are factors which satisfy the Section 8.5 test. No, that wasn't the approach. The approach taken, and there's no dispute about it, and it is plain from the materials that I showed the board earlier today, the minister adopted the approach that he, for his part, would have wished to go a lot further to recognise same-sex marriage, but it was simply not possible to do so because there was a large section of the community that wouldn't accept any such conclusion. So a political compromise was achieved. And I do not accept as a basic proposition of constitutional law, for the reasons I identified at the outset of my submissions, that a political compromise of that sort, although perfectly understandable, I don't criticise it in political terms, carries any weight whatsoever when the board performs its constitutional functions of assessing proportionality at this stage of a constitutional analysis. The state cannot rely on political strengths and political weaknesses. It cannot rely on the mere wishes of people in the community. As Lord Bingham said in Reyes, and I showed the board the relevant passage yesterday, political opinions counting votes is simply not relevant to the issues that are raised in a constitutional analysis. So for all those reasons, I respectfully submit that if the board is persuaded by my friends that it is appropriate to assess justification, my friend fails the justification test at each of the levels at which proportionality is relevant under Section 8.5, and we rely on the analysis in Halpern, which we say is correct in principle as to the way in which proportionality should be addressed in the circumstances of this case. Those are my submissions on justification in relation to Section 8.5. The same arguments apply in relation to Section 12, Section 12.8. My friend, and I don't criticise him, did not separately deal with justification under Section 12, but there is a proportionality, a justification test in Section 12.8, and I'm, for my part, am not seeking to distinguish on justification between Section 8 and between Section 12, and nor did my friend. If I've misunderstood him, he will say so in his reply. And I see him helpfully shaking his head. So there's agreement on that. Then I need to turn, if I may, to Section 12. And it is our submission that there is also a violation of Section 12 of the Constitution, that is discrimination by creed. Now, on this one, we succeeded before Chief Justice Caverley, and we lost on this issue in the Court of Appeal. And the reason why we lost in the Court of Appeal was because the Court of Appeal accepted the substance of the first point raised by my friend Mr. Crowe yesterday on Section 12. And his first point, the board will recollect, is that Section 12 is concerned with discrimination by reference to a belief system, as he put it, not an isolated belief. He said the purpose of section 12 is to prohibit rules of the sort no Sikhs allowed. We say that section 12 is wider than that. We would say, if it matters, much wider than that, but it's not so confined. And if I take the board, please, back to section 12 on page 1386, we see how the drafters of the Constitution have framed the provision. Section 12(1), subject to the provisions of 4, 5 and 8, no law shall make any provision which is discriminatory either of itself or in its effect. And then subsection 3 tells us to whom this applies, by race, place of origin, political opinions, colour or creed. And we're given some help. What we're looking for are disabilities or restrictions, as opposed to privileges and advantages. My point is that section 12(1) is not simply concerned with overt discrimination. It's concerned also with discrimination in its effect, what for an English or British discrimination lawyer would be understood, the analogy is not exact, but it would be understood as indirect discrimination would be covered. So that's the scope of section 12. And we do say, my friends, narrow approach to creed is only concerned with a belief system is with respect erroneous. And we do say that there's no good reason why the concept of a creed in section 12 should exclude a specific belief, provided that it is sincerely held as a significant part of a general set of beliefs. Again, I rely on the Reyes principle. These rights should be broadly construed. But I also urge upon the board that if my friend Mr. Crow's restrictive approach were to be adopted, it would remove much of the value of section 12 as a constitutional guarantee. Let me give an example. Suppose the law of Bermuda were to provide for a prohibition on the wearing in public, perhaps even in private, but certainly in public, of a skull cap or a face covering or a crucifix. Now, for many adherents of the creed, whether it's Judaism, being a Muslim, being a Christian, that simply wouldn't matter. It wouldn't matter at all. But for some members of the overall creed, it would impose disabilities or restrictions, that's the wording used in section 12, disabilities or restrictions affecting what they regard as a significant aspect of their creed. And my friend's approach that one's only here concerned with discrimination which affects the belief system as a whole would fail to cater for such a typical cases which have troubled courts around the world. And in all of those cases, the real issue, and it's often been an extremely difficult issue, is justification. Is there an adequate justification for the state saying to the schoolgirl, you can't wear a hijab, for saying to the worker in a hospital, you can't wear a crucifix? Cases in France that have gone to the European Court of Human Rights saying you can't wear a head covering in a state institution, in a university or a police station or matters of that sort. These are difficult cases, and there's a whole variety of different answers given in different circumstances. And there are cases not just in the United Kingdom, in Europe, in Canada, all over the world. My point is that we are very concerned, as part of our submissions, that my friend's narrow definition simply would exclude that whole category of cases. And we do say once, yes, my Lord, Lord Hodge.
That category, would that category of cases be covered by Section 8?
Well, they may be. They may not necessarily be if my friend's very narrow approach to Section 8 is a correct approach, because it may be that the wearing of that particular item may not fall within the narrow definition that he seeks to give to Section 8. But even if they were to be covered by Section 8, Section 12 serves a very useful purpose, because it allows expressly for a comparison, discrimination analysis, which Section 8 is not of itself concerned with. And I say that one has to look at Section 12 on its own, because it is a discrimination clause. But there may be other examples that don't fall within Section 8. One of the examples that's given in Dr. Campbell's affidavit that concerns him is the question of what happens if the state were to prohibit divorced persons from having a valid marriage, perhaps for religious reasons. Nobody who is divorced may marry. It might be said, and it has been said by Mr. Crowe, well, that wouldn't fall within Section 8, because it's not personal, it's not unilateral. You're talking here about the state recognizing a marriage. And we would certainly say in that context that provided there's a religious or conscientious belief, as there is by the churches with which we are here concerned, such as Dr. Campbell's church, that divorced people should be allowed to have a valid marriage, then if Mr. Crowe is correct on Section 8, then Section 12 will be needed to advance a discrimination argument by reference to creed. So I do say that there's a real need to, in my submission, be very careful not to adopt a narrow approach to the scope of Section 12 and deny the possibility of arguments which will depend upon justification. The board, in my submission, will recognise just how fundamental this issue is to the creed of many, many people. There's ample evidence that for particular religious groups, it is a fundamental part of their creed that same-sex marriages are valid. They regard their creed as requiring dignity, equality, respect for same-sex couples, and the recognition of that by the state. And the evidence shows, sadly, that there have been schisms in religious communities and communities defined by reference to creed, particularly by reference to this issue. For example, Dr. Campbell, page 868 at paragraph 8e. These are fundamental issues of the creed of individuals as they define them. And I respectfully submit that just as the authorities show, it's Law Mance in Larimore, that one adopts a subjective approach to what is a person's religious and conscientious opinions, equally one adopts, I submit, a subjective approach to what is a person's creed. So we say respectfully, there's no basis at all for that first argument by my friend excluding this case from section 12 in limine. His other point, my friend's other point, which wasn't accepted by the Court of Appeal, but the other point that my friend advances is he says the disabilities or restrictions in this case are not attributable to the respondents' creeds. They are attributable to the law not allowing a same-sex couple to marry. That's his argument. Now, I say with genuine respect that is a circular argument which frustrates the purpose and it frustrates the effect of section 12. The persons whose creed includes a belief in the validity of same-sex marriage are subject, this is the language of section 12.3, they are subject to disabilities or restrictions precisely because the law does not allow them to implement that belief fully by entering into, by celebrating, by officiating at a same-sex marriage. By contrast, those whose creed involves a belief only in opposite-sex marriage do not suffer that detriment. And the appellant's approach, my friend Mr. Crow's argument, this second argument, ignores, if I may say so, the very basis of the respondent's creed, which is a creed focused on the belief in the validity of same-sex marriage. And if that can be a creed for the purpose of section 12, that was the first argument that I addressed. If it can be a creed for the purpose of section 12, that is a belief in the validity of same-sex marriage, then his second point adds absolutely nothing, because he is seeking to ignore the very disability or restriction which the creed believes in, that is, protection by law. those are my answers to the 2 points. My friend dealt with this briefly, no harm in that, but those were his 2 points on section 12, and we say respectfully that neither of them is an answer to our reliance on section 12. Yes, my Lord Sales had a question.
Yes, on your account of creed, people can hold the belief that on account of human equality and dignity, there should be the possibility of same-sex marriage, whether they wish to enter into a same-sex marriage or not. I mean, your argument would have to involve, wouldn't it, that they get prevented from marrying, even though they don't want a same-sex marriage? Wouldn't that be the basis of different treatment attributable wholly or mainly to their creed, as you define it?
Well, yes, but that would be true in a standard case of a section 12 protection. To take the simplest case that Mr. Crowe recognises, and I think he accepts that were the law to provide that kosher meat shall not be eaten, or something along those lines, that would fall within section 12, whether or not there are people who identify themselves as Jewish who couldn't care less about whether meat is kosher or not. It really doesn't matter. The only people, of course, who could complain under section 15 1 is a person who alleges that any of the foregoing provisions of the chapter has been, is being, or is likely to be contravened in relation to him. So I suppose if it were purely abstract matter that didn't really concern the individual, then it'd be difficult to see how they have standing. But in any event, I would say that all those who have this creed, as I've defined it, are adversely affected in the context of the legal validity of same-sex marriage, because whether they wish to marry or not, if they hold this creed, they are likely to want to celebrate such marriages of their children, their parents, their friends, or their people, like some of the respondents in this case, who wish to officiate at such at same-sex marriages which have legal validity. So I wouldn't, with respect, accept that the only people are the people who are wanting to enter into a same-sex marriage. No, my lord.
Yes, thank you.
My lords, subject to any other questions, I have 2 final points. One is really formal. I said yesterday, again I misspoke, I think I said that Professor Nayem, he's the distinguished academic who spoke about the problem for those who don't have a same-sex marriage, were they to travel, as people do, to America for health reasons. I think I said he's a professor at Harvard, whereas in fact he's a professor at Yale, and I of course apologise to him. The board may remember that Abba Eban, the distinguished former foreign minister of Israel, who was wrongly said to have been educated at Oxford, he pointed out it was Cambridge, but as he said, one must expect to be smeared in public life. The other point, which is more substantial, is this, and I won't take long on it, but I think I should mention it. My friend Mr. Crowe opened his submissions yesterday by drawing attention to a letter from out Bermuda, one of my clients, dated the 15th of November 2017. The board will remember the letter. It was at page 906, where certain views were expressed, and Mr. Crowe made merry of the jury point that arises out of that. My answer to my friend's submissions on that point is this: the board, I say, will appreciate that in the political world, out Bermuda has to do the best it can to advance the interests that it represents. And it did so in the political circumstances that prevailed at the time. None of the other claimants have expressed any such view. And in any event, I say that the views expressed by out Bermuda are irrelevant, and they are irrelevant because the board is determining questions of law, very important questions of law, and they're not defined, those questions, they're not answered, as I've submitted, by public support, by political support, or indeed what can be achieved in the political world. The whole point of constitutional adjudication is precisely to confer rights that are not dependent on political vicissitudes. And that is of fundamental, I say, of fundamental importance when the board looks at these questions. And indeed, Lord Bingham made that clear in the Reyes case, and he also made it very clear in the case of A against the Secretary of State, which was the very familiar case relating to Belmarsh. And your lordships have that at volume 1, tab number 15. It's at bundle reference 1617. And the board may recall that it was the case where Lord Bingham, speaking for the appellate committee, was highly critical of the argument that was advanced by the then Attorney General. It's at page 1659. This was the very, the board remembers, a very sensitive case where immediately after 9/11, Parliament decided that it was appropriate for foreign nationals who were suspected of involvement in terrorism to be detained without trial, and only foreign nationals, not British nationals. And the appellate committee held that that was unlawful. They gave a declaration of incompatibility. A very sensitive, important case. At 1659, at paragraph 42, picking it up in the 5th line, Lord Bingham, speaking for the appellate committee, I think Lord Walker dissented, but it was the other 7 judges agreed with Lord Bingham on this. It follows, I do not accept, said Lord Bingham, just under E, the full breadth of the attorney's submissions. I do not in particular accept the distinction which he drew between democratic institutions and the courts. It is of course true that judges in this country are not elected. They're not answerable to Parliament. It's of course also true that Parliament, the executive and the courts have different functions, but the function of independent judges charged to interpret and apply the law is universally recognised as a cardinal feature of the modern democratic state, a cornerstone of the rule of law itself. The attorney is fully entitled to insist on the proper limits of judicial authority, but he's wrong to stigmatise judicial decision-making as in some way undemocratic. It's particularly inappropriate in a case such as the present, in which Parliament has expressly legislated to render unlawful any act of a public authority, including a court, incompatible with a convention right, and it's required courts to take account of Strasbourg jurisprudence. And the particular reference that I wanted to draw to the board's attention is on the previous page of that, as one of the many authorities supporting that approach. It's at page 1658, and Lord Bingham refers to a number of matters. In particular, letter B on 1658, there's the reference to the judgment of Justice Jackson, Robert Jackson, sitting in the Supreme Court of the United States in West Virginia State Board of Education and Barnet. He stated, speaking of course with reference to an entrenched constitution, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, to establish them as legal principles to be applied by the court. We cannot, because of modest estimates of our competence in such specialities of public education, withhold the judgment that history authenticates as the function of this court when liberty is infringed. Fine words, but in my submission, accurate words as a matter of principle. It is simply irrelevant, although I understand why Mr. Crowe draws attention to it, of course. It is simply irrelevant what are in Bermuda the current or then political controversy and vicissitudes. I invite the board to put that to one side, and for all the reasons that I have sought to advance, to accept that as a matter of constitutional law, which is all that the board is concerned with, the Court of Appeal was right on the primary religious purpose issue. It was right on the breach of Section 8, the primary religious purpose contrary to Section 8. It was also right on the breach of Section 8 by reason of effects, and we allowed the board to also, if it needs to, allow the cross appeal on the breach of Section 12. I've done slightly better than my time allocation. I hope none the worse for that. I'm very happy, of course, to try to answer any further questions, but for my part, those are the submissions that I wish to make to the board.
Well, there don't appear to be any questions, so thank you very much, Lord Pennick.
Thank you, my lord.
We'll turn back to Mr. Crowe for his reply.
I'm very grateful. May it please you, my lord, my ladies, I was going to take the issues, obviously in the same order in which my learned friend dealt with them, starting with the religious purpose rule. And starting with that, it is important just to recognise the terms of the debate that we are now having, because it is perhaps unkind but certainly true to say that there has been a double retreat on my learned friend's part in relation to the legal argument that is being run. As I showed when I was opening, the Court of Appeal decided the religious purpose rule entirely separately from any consideration of Section 8 of the Constitution. The learned friend now accepts that in order to persuade this board that the revocation provisions are unconstitutional, he does have to satisfy you that there has been a violation of Section 8. The second element of the retreat is that whereas my learned friend's written case presents an argument which appears to suggest that legislation will be unconstitutional purely by reference to its purpose, on analysis, and perhaps conscious of some of the lines of questions, my learned friend's position has actually moderated on that too, and he repeatedly talked about the need to prove hindrance under Section 8. And the very first thing he said yesterday afternoon was an illustration of that. He said, that in order to implement, legislation enacted in order to implement a religious tenet is a hindrance to religious freedom. So the terms of the debate, just to be clear about what argument we are having, we are only having an argument within the four walls of Section 8 of the Constitution, and the learned friend recognises that he needs to demonstrate there has been some hindrance to freedom of conscience, because that is what Section 8 says. So the argument between us essentially is, well, what does hindrance mean? How broad a concept is that? And in our submission, the only proper approach to an analysis of the constitutionality of legislation is to consider the matter by reference to what we have called an effects-based test. Hindrance means some kind of identifiable interference with enjoyment of the rights that are guaranteed by Section 8. My learned friend started by trying to uphold his reliance on Reyes in this regard. Could we just go back to that very briefly? It's at page 4967. And it's paragraph 26. It is entirely true that Lord Bingham there cites Big M Drug Mart and, as my learned friend points out, specifically page 331, which does include the passage on which my learned friend would wish to rely. But the fact is that the issue that is being addressed in paragraph 26 is simply a question at a high level of generality as to the appropriate approach to the interpretation of constitutional legislation. It is not talking at all about the ability of courts in any jurisdiction to strike down legislation by reference to their purpose. So my learned friend simply doesn't get the proposition other than by indirect reference from a page reference. And in our submission, yes, as my learned friend said, certainly Lord Bingham was a clever and careful person. Even Homer nods. We do not get from paragraph 26, in Lord Bingham's words, any support for the proposition on which my learned friend seeks to rely. And so in our submission, you certainly get echoes of the points that we have seen from Matadine and Quantu and from Fisher about a generous approach to interpretation, and the reminder that it is still nevertheless an exercise in interpretation. But you simply do not get Lord Bingham giving support to the points that my learned friend would wish to rely on. And so in our submission, the starting point is that there is not at the moment Privy Council support. And apart from anything else, it would have been utterly irrelevant, technically obiter, to be expressing any view in Reyes on what is or isn't constitutional legislation in terms of purpose. It was one of the many mandatory death sentence cases. So the point that my learned friend would seek to get from it simply wasn't even an issue. His second port of call was Big M Drug Mart. We've already taken you through that in our opening. As I said when we were doing that, it does undoubtedly contain some words that say that legislation will be unconstitutional purely by reference to its purpose, and I accept that that's there. The challenge for this board, if I may say so, is first of all, having got through to the end of that judgment, and including the passages I took you to yesterday, is whether in fact that is what Big M Drug Mart is saying in its own terms, and if so, whether it survives what is said in Saguenay. Because you will recall very clearly in paragraphs 82 to 84 of Saguenay, the court there, purporting to follow Big M Drugmart, expressly turn from purpose to consider whether there is any interference with the enjoyment of religious rights. And it is impossible with respect to read Saguenay as being itself an endorsement of the pure purpose approach to the test of constitutionality. And so the first challenge for this board is reading the totality of Big M Drugmart and Saguenay, whether you do in fact find that as a matter of Canadian law, it is true to say that a piece of legislation will be unconstitutional purely because of its purpose. And secondly, one then has to assess whether, the challenge for the board is to assess whether that is a principle that ought to be carried across into the, into the constitutional law of Bermuda. On that point, I think my Lord Hodge intervened and asked whether it was not the case that specific provisions of the Canadian Constitution formed part of the ratio in Saguenay, and indeed they did. It was, I think, section 27 of the Constitution, and it certainly appears at least in paragraph 74 of Saguenay in terms, which is page 3573. In relation to the Canadian cases, that's at the moment all I wanted to say. My learned friend's next port of call was going to be, section 15 of the Constitution. If we could just go back to that, because that in our submission is again a point in our favour. Section 15 of the Constitution is to be found at page 1482. And you'll recall that what it says is that if any person alleges that any of the foregoing provisions of this chapter has been, is being, or is likely to be contravened in relation to him, then without prejudice to any other action with respect to the same matter that is lawfully available, that person may apply to the Supreme Court for redress. In our submission, section 15 makes it perfectly clear that a violation of the Constitution is assessed by reference to an effects-based test. Yes, it certainly allows somebody to apply, so to speak, on a quia timit basis if he anticipates that effect about to be delivered against them, hence the words or is likely to be, but it is entirely looking towards a personal, as I say, effects-based complaint based on a breach in relation to a particular person or an anticipated breach. That approach provides no support at all, and indeed quite the contrary, provides no support at all to the proposition that legislation can be declared unconstitutional, not on the basis that it has been, is being, or is likely to be contravened in relation to him, but that there is some purpose out there that is religious. So with respect, section 15 does not provide land for any support. And in our submission, it actually underlines the effects-based nature of the test for a breach of the Constitution. My learned friend's next case was Larimore, which he went to a number of times. Sorry, that's not a criticism, but it's an interesting case. It starts at, as you may already have a note, it starts at page 2153. My learned friend sought again to derive some support from this case for his purpose-based test for unconstitutionality. In our submission, it is quite clearly an effects-based case. Larimore was quite clearly a case involving direct coercion, a requirement for compliance with a religious practice which was overtly Christian, and the caps off order was understood and entirely understandably regarded as being a requirement to show respect for the Christian religion, and that element of coercion is essentially why the provision, the measure in that case, was considered to be contrary to the constitutional protection of religious belief. And if one looks, I'm not going to reread it, but if one goes back to paragraph 11, which was the paragraph my learned friend wanted to rely on, it specifically uses at letter E the word interfere. Conferral of guarantee of freedom of conscience or religion constitutes a promise that such freedom will be protected and not interfered with by the state. So with respect, Larimore is not support for any purpose-based approach to determining the constitutionality of legislation. It is another illustration of a situation where legislation is held to be unconstitutional because of direct state action involving coercion, i.e. interference. Macfarlane. My learned friend went back to Macfarlane. I'm not going to ask you to turn it up again. For all the vigour of what Lord Justice Laws said in that case, the fact is it is not of any assistance to you at all. My learned friend has no answer to any of the points of analysis that we offered. Indeed, he accepts self-evidently that the case is nothing to do with the Constitution of Bermuda. He accepts inevitably that the case is nothing to do with the determination under the jurisdiction of any country of the validity of legislation. Yes, Lord Justice Laws said what he said about legislation being passed for religious purpose being deeply unprincipled or unjustified. But as we say in our case, and learned friend has no answer for this, if any lawyer makes a proper legal proposition, one immediately has to ask, well, for what purpose? And by reference to what test are you offering that proposition? Simply to say that legislation passed for a religious purpose is unjustified prompts the question, well, basically, what are you talking about? Unjustified as a matter of political philosophy? Unjustified as a matter of constitutional law? If so, whose constitution and by reference to what test? And the moment you drill it down, all that Lord Justice Law's remarks do is drive you back to the test that you are having to apply, which is legislation passed in Bermuda which declares that only marriage between a man and a woman will be recognized in law beyond the legislative powers of the Bermuda Parliament under the Constitution, knowing that it has plenary legislative power subject only to the provisions of the Constitution. And the only provision of the Constitution on which these claimants, these respondents now, seek to rely is Section 8 and Section 12 in due course. So, looking at the words of Lord Justice Laws, stirring though they are in the abstract, they provide you, with respect, with absolutely no assistance in resolving the issues in this appeal. Going through the various rhetorical questions that we ask in our case and providing the answers, the one point, well, actually, the 2 points that we would just wish to remind you about. First of all, there's the question of, is it the sole or the primary purpose that has to be proved to be religious, if this religious purpose principle is to be accepted? My learned friend drew your attention to a passage in Big M Drug Mart at 4802 that suggests that primary purpose is sufficient. You may recall that I drew your attention to a passage 2 pages later, which says sole purpose. So as with a number of different aspects of Big M Drug Mart, you do get mixed messages from it. The other question, which is important because it then feeds into the question of the appeal from the Chief Justice to the Court of Appeal, is the question of whether, if you are applying this religious purpose test, whether the test is being applied section by section or to the legislation as a whole. Our submission, as you will gather from our opening, is that just as you interpret individual statutory provisions by reference to the overall context in which they appear, namely, largely, the Act as a whole, similarly, you must, as a general proposition, assess the purpose of an individual provision by reference to the context in which it appears. That is particularly true, as I say, that we offer as a general proposition. But we do also urge on you, and again, my friend didn't answer this point directly, we do urge it on you as a specific submission in relation to the facts of this case. Because although my learned friend spent a considerable amount of his time taking you to observations in Hansard suggesting that some opponents of the of same-sex marriage had religious motivations, the one thing on which we are agreed is that when you are assessing the purpose of the legislation, the exercise requires you to assess the purpose of the Parliament as a collective body. Now, we know in this case, and I am incidentally grateful to my learned friend for reading at some length the observations of the Minister at the second reading, because that demonstrates very clearly and very helpfully for our case that this plainly was a compromise piece of legislation. To say compromise means necessarily that the collective will of Parliament involved an accommodation. The collective will of Parliament was not to achieve individual results. This is not a single issue piece of legislation. The very fact that it is a compromise means, in our submission, by definition, the Act cannot have had a religious purpose. And that's also why that passage from Sullivan might be useful, because it draws your attention to the difference between motive, because individual MPs may well have personal motives for voting in support of one provision or another, or being more enthusiastic about particular provisions rather than others. But since we are agreed that the legal question involves an assessment of the collective purpose of Parliament, our submission is that the very fact that the legislation necessarily includes some provisions which please some quarters and some provisions which displease those quarters but please other quarters, what that means is that the collective purpose of Parliament is not to do the bidding of any particular interest group at all. It is indeed to achieve a compromise by giving some to some and giving some to others. So the collective purpose cannot properly be described as religious. And in our submission, that is an extremely important factual point. And it was a factual decision by the Chief Justice that the purpose of the legislation was not religious. That was a finding of fact. The Court of Appeal was only entitled to interfere either if there was no evidence to support it, which is not the argument being made against, or if the Chief Justice made his finding of fact on the basis of a misunderstanding of the law. And the Court of Appeal did overturn his finding on that basis. They said, all right, that was his finding of fact, but he misapplied the law because he reached that finding of fact by assessing the purpose of Section 53 in the context of the Act as a whole, instead of salami slicing and just identifying the purpose of Section 53 on its own. If you are with us, that the correct approach to analysing the purpose of legislation is to analyse the purpose of the whole package, a fortiori, as I say, in relation to a compromise package, then the Court of Appeal had no business to overturn the first instance judge's finding of fact. That is also an extremely important point in the legal analysis, just to loop back into the legal analysis, because if you accept that approach, then the legislation does not offend even the Canadian approach to the protection of religious belief, freedom of conscience. Because you will see in Saguenay repeatedly that the way the court describes the breach of freedom of conscience is to say that the state's duty of neutrality is broken if the state adheres to a religion to the exclusion of all others. And it's the leitmotif to the exclusion of all others that comes up again and again. I'll just give you two references, but in the judgment, it's in Paris 76 at page 3574, and again in paragraph 84 at page 3577. I read it to you yesterday, but I just wanted to emphasize that wording. Adhering to a religion to the exclusion of all others. That is, even if you were to accept the Canadian approach in all its glory as part of the law of Bermuda, this legislation doesn't offend that because it is a package of compromise. It is not adhering to a single religious creed. If it had bowed to the wishes of the, acted at the behest of a preserved marriage Bermuda, then no doubt it would never have introduced domestic partnerships. It is precisely because domestic partnerships were introduced that perhaps one quarter of the community is unhappy. It's because marriage for same-sex couples are not provided for, that another sector of the community is not happy. But the outcome, as we say, is an accommodation between competing elements, and it cannot therefore be said, even if you accepted the Canadian approach, that this legislation represents the state adhering to one religion to the exclusion of all others. So in our submission, that is an important issue, both in legal terms and also in relation. My lady Arden has a question.
Yes, I don't mean to interrupt your sentence. The submission you are making that it's an answer that there was a compromise would seem to suggest that the protection of minority rights is not present if you can show a compromise. Am I reading too much into the submission?
I'm not sure I understood the question. I do apologise.
Well, you're saying if there's a compromise of what everybody wants in the legislature, that is the end of any question of minority rights, because it's a complete answer that the representatives in the legislature have agreed upon a compromise. Maybe there are minorities that are not represented in the legislature and therefore are not part of your compromise.
I'm addressing a different point, my lady. I'm not at the moment addressing any human rights question, and I'm certainly not addressing any question as to whether or not there is discrimination or fair balance. The only point I'm addressing at this stage, and we're still on the first main issue in the appeal, is whether or not, assuming against myself, you accept that there is some religious purpose rule which means that legislation is struck down because it has a religious purpose. I am simply saying that this legislation cannot be judged as having a religious purpose because it represents a compromise. and that is all I seek to get out of this sort of particular thread, my lady. I hope that clarifies where I'm going. The other point I just wanted to make on this is that my learned friend, in the context of his objection to the argument on justification, said, well, they would have asked for cross-examination. Religious purpose was an issue from the outset, and Miss Ajar put in 2 witness statements in the Bermuda case and 1 witness statement in the Ferguson case. She says in terms that the government was not influenced by preserved marriage Bermuda and was not motivated by religious purpose in putting the legislation forward. That's her evidence, and she says at the beginning, I am the permanent secretary. I speak from personal knowledge. And if you want the references, paragraph 8 of her statement at page 890 and paragraph 22 at page 893. That was, if the claimants wished to challenge that evidence, she should have been cross-examined on that, and she wasn't. And so with respect, not only was the Court of Appeal not entitled to overturn the Chief Justice on their view of the law, because their view of the law was wrong, but he was right on the facts. And with respect, it's not open to the respondents now to challenge evidence on which there wasn't cross-examination at the time. Sorry, can I just check if I need to cover another couple of points before moving on? Yeah, there was one intervention from my Lady Arden while my learned friend was speaking, in which she drew attention to the way that Section 53 dealt with the judgment in Godwin. And she pointed out that it didn't say Godwin is overturned. That is true. I'm not sure what my learned friend would wish to derive from that, but the 2 submissions we would wish to make about it are simply these. First of all, as I hope I explained in opening, the judgment in Godwin was a judgment based on the effect of the Human Rights Act of Bermuda. It is part of the structure of the Human Rights Act of Bermuda that other legislation can override it. And that is what Section 53 and Section 48 of the Domestic Partnership Acts, the Domestic Partnerships Act does. So the Domestic Partnerships Act merely operates one of the permissive elements in the Human Rights Act, Section 30, capital B. So nothing surprising there. Second point, if any significance were sought to be attached in relation to the issues in this appeal, to the fact that Section 53 says, notwithstanding the judgment in Godwin, rather than Godwin is overruled, if any significance is sought to be attached to that difference of wording, we would object with respect that would represent a triumph of form over substance. The language in which Section 53 clarifies the law that only a marriage between a couple of the opposite sex will be recognized in the law raises a point of substance, namely, can Parliament pass that legislation? The answer to that question turns on whether it's valid within Section 8 of the Constitution. It cannot, with respect, the answer cannot turn on the question of whether Section 53 says Godwin is overturned, rather than notwithstanding the judgment in Godwin.
But it's a preliminary question, isn't it, what the statute means, and the courts are obliged to pay attention to the wording.
Absolutely. Absolutely. So, I slightly got ahead of myself in the sense that I was addressing you by reference to my learned friend's submissions on the existence of the religious purpose rule. He then moved on to the factual question, whether or not the legislation was passed for a religious purpose rule. In our submission, I think I have probably said everything I need to say. We just wanted, in a sense, to commend to you what the minister said in opening the second reading, as, if we may say so, an entirely clear, accurate, and fulsome explanation for the decision that was taken in that case to support that legislation. So that's the religious purpose rule. Moving on to section 8 and the effects, so to speak. My learned friend's first port of call here adds to under the heading of whether or not the beliefs of the respondents are protected by section 8. The starting point is that there is no disagreement between us about the proper characterization of the beliefs. You may recall I took you to a paragraph, I think 79 in the first instance judgment we mentioned, and 57 in the Court of Appeal judgment. The belief is, on which all the respondents seek to rely, is a belief about marriage as an institution recognized under the law. So the question with which this board needs to grapple is, does freedom of conscience entitle a claimant to demand protection from the state in the form of making legislation? That is essentially what the content of this belief is said to confer on the respondents. My Lord Reid, in the course of my submissions yesterday, asked whether we would accept that Section 8 would ever impose positive obligations on the state. I don't think we need to take a position on that. It's difficult to say never. But what we certainly say is that in terms of the content of any meaningful interpretation of the expression freedom of conscience, which is then coupled with an entitlement to manifest the belief in worship, teaching, practice, and observance, that cannot be extended to claim entitlement to protect, so to speak, the content of a belief, which itself is a demand for legislation. And so when my learned friend then turns, for example, to Williamson, which it was his first port of call in relation to the question whether or not the beliefs are protected by Section 8, what you get from Williamson is a threshold point. Yes, nobody is suggesting that the beliefs have to be super clever or any particular level of importance before they are protected. But that's not the point. The Attorney General has never been running the argument these beliefs aren't important enough to be protected by Section 8. The argument is that Section 8 protects beliefs which can properly be described as matters of freedom of conscience, and a belief as to what the civil law of the state ought to confer by way of legal recognition on particular relationships is not properly understood as falling within that. And my learned friend, with respect, doesn't offer you a satisfactory answer in relation to that. Entering into a marriage, as that very short passage from Bellinger in the Court of Appeal illustrated, you remember, quoted in the Hong Kong case. Entering into a marriage is not a unilateral act by somebody as an expression of their belief. It is, my Lord Sales.
I didn't mean to interrupt your sentence. Do finish that and I'll ask my question.
I've forgotten what I was going to say, my Lord.
All right, in that case, I'll ask my question. Might it not be said that the significance of legal recognition comes as part of a chain of reasoning? It doesn't stand by itself. The reasoning being, perhaps one might summarize it as all humans are equal and entitled to respect for their dignity. Loving relationships are central to our lives and our humanity. There's no lesser quality to love between same-sex couples and a man and woman. And marriage is a public institution which gives the recognition and support of the state to that central human relationship. And then in the context of a regime where the state does positively give its endorsement to that institution as it exists between a man and a woman, but withholds that endorsement and, if you like, legitimacy from the equivalent relationship between the same-sex couple.
Sorry, I was just trying to check. Yes, I mean, could I offer an answer in two parts? I entirely take, I think, part of the thrust of your Lordship's point. But what we would suggest that leads to is a world in which, yes, one can quite see that depending on the terms of the legislation, that might prompt a debate by reference to rules against discrimination. And it might justify the kind of approach one saw in Obergefell if the constitutional protection is of the open-textured US principle of personal development. I was trying to find the expression in Obergefell and failed in the time. But the fact that there may be other hooks on which to hang that sort of thread of reasoning doesn't support the argument, with respect, that the belief as to what the law ought to recognise by way of conferring the title marriage to any particular union is a matter of conscience, which is manifested not in fact by doing anything oneself, which is what manifesting normally involves, but by demanding overt action from the state in the form of enacting legislation. So I entirely understand why the sort of the reasoning that your Lordship has just put to me could well lead, as I say, depending on the wording of the Constitution or the legislation, to arguments on discrimination, if that label is applied in one situation and not another. And I can entirely understand it if the constitutional right on which reliance is being placed is an entirely open-textured one, which embraces an almost abstract concept of personal development. But that is just not what Section 8 of the Constitution contains. And one can quite see, and in a sense, I'll pick this point up now. My learned friend, when he was dealing with Section 12, was pushing for a wide interpretation and saying, oh, well, look what might fall outside the terms of this Constitution if you adopt what he would call my narrow interpretation, and we simply say giving effect to the words. The fact that constitutional provisions have specific defined effects does not mean that the courts are entitled simply to expand them to mean something different because something has fallen out of the pot, which we might now, as a matter of policy, think ought to be kept within the pot. The fact that a legislative provision is made in 1967 defining, for example, discrimination in the way it is in section 12, may now be regarded as being of limited value. And that may well be an explanation why the Parliament of Bermuda, 20 years later, decides to pass a Human Rights Act and then to amend the Human Rights Act, defining discrimination more broadly. But those are legislative decisions which the Parliament takes. It shouldn't be treated as the fact that the wording of the Constitution is itself finite and clear. Yes, you give it a generous interpretation, but with respect, you should not get into the territory of what Lord Hoffman created as being divination.
I wonder, in thinking about Lord Sales's point, the point he's making is one which resonates in the context of a provision such as Article 8 of the ECHR, or Article 14 taken in conjunction with Article 8. But the problem with trying to apply Section 8 to it, as it seems to me at the moment, is that even if you are able to categorize this sort of belief as one that falls within the scope of Section 8, you're perfectly free to hold the belief. You're perfectly free to express it. Nobody's going to discriminate against you because you hold that belief. And so Section 8 and Section 12 don't at the moment seem to me to bite on.
Well, my Lord, with respect, that is certainly an approach we would invite you to, you all to adopt. And it does bring us back to the important urgings that we would press on you, that this is, as the learned friend has said, a question of law. You should not be confused, and particularly if you are hearing another appeal which may raise different points of law, the debate and the decision must not be confused either by taking into account other questions of law, let alone any underlying feeling that somehow the general direction of travel in Western countries seems to be towards same-sex marriage, and therefore somehow one ought to find a route to achieve that here, because that would be working backwards and it would not be approaching it as a legal question. My Lady Arden.
Only if my Lord the President has finished the question. If I may ask this, it's part of the respondent's case, not simply that rights were withheld, which was the word my Lord Sales used, but that rights were taken away when Section 53 was implemented. Does your answer change in any respect if that is made good?
Thank you, my Lady. Could I answer that in two parts? The first is that the question under the Constitution, which is all this board is dealing with, must be answered by reference to whether any rights under the Constitution have been violated.
I hadn't understood that. Why couldn't they be rights conferred by the case law, like Godwin?
The simple answer to that is that the question whether or not the legislature is entitled to pass legislation has to be answered by reference to what its powers under the Constitution are. The question can't depend upon whether there has or hasn't been a judicial decision under the Human Rights Act in circumstances where it is inherent in the Human Rights Act that whatever it provides can be overwritten by other legislation. I was just going to say it would be an extremely odd ratio if one were to articulate the outcome in this appeal with the implied message that if this case had been decided before Godwin, the government would have won, but because it's being decided after Godwin, the government loses. And in our submission, that is one part of the answer. The other part of the answer, as I say, is that although Godwin was not appealed, we have put in front of the board the material that we say should be taken into account, not with a view to deciding that Godwin was wrongly decided, but at least to put you in the frame of mind of approaching the constitutional question in a sense blind to what the answer under the Human Rights Act is, because Godwin might be right, but it might be wrong. So approaching the question of whether or not the legislature had the power to enact Section 53 and the cognate provisions should, with respect, simply be taken by reference to, has there been a hindrance under Section 8, rather than by feeling one's way forward to thinking, well, has a right been taken away that did exist? Because that then takes you down the route of having to satisfy yourself that the right was in fact properly identified. And with respect, I would urge you that would be a distraction. That's a cosmetic issue.
Well, on your case, as I understand it, this appeal is not concerned with the right to marry of people of the same sex. It's concerned with the right to hold the belief that people of the same sex should be able to have a legally valid marriage. And the issue is whether that belief is one which is in some way hindered, contrary to Section 8, or its manifestation is hindered, or people who hold that belief are discriminated against, contrary to Section 12.
Exactly so.
I don't think what I was putting to you would necessarily go against that. The belief is that persons of the same sex should have the same recognition, same right to recognition of their union as persons who are heterosexual couples. And the belief that that is consistent with human dignity and so on. I don't need to enlarge on it. If Godwin represents good law, then prior to Section 53, one of the ways in which that right could be manifested, or one of the ways in which it existed, was by actually undergoing or participating in or officiating at a ceremony of same-sex marriage. And if Godwin was good law, that was a right. That's what I think the argument is I'm trying to ask you to deal with, because then it would be said, well, the Human Rights Act override power, of course, can be used to take away a right, but it doesn't mean to say it's right to take away a right.
Could I perhaps also just ask Lord Sales, because I see he has a question too.
Well,
to answer them later.
Well, no, I think answer my lady's question and then I'll ask mine separately.
As I say, well, I take my lady's point, but I don't think I can give a better answer than I have already, which is that the question that you are being asked to answer involves the stage-by-stage analysis. First of all, is there a protected belief? And secondly, has there been a hindrance with a manifestation of that belief? Those questions are not answered by reference to whether or not there was, under the Human Rights Act, a right to marry. They are answered by reference to what is the scope of Section 8 of the Constitution. So in our submission, it is a purely cosmetic consideration whether or not this case is being decided before or after Godwin, because that is a question only under the Human Rights Act. We are only concerned here with whether or not the threshold question of is this a belief that's protected by Section 8? And secondly, is there an interference with a manifestation of that belief? And neither of those in our submission are in the answer to neither of those. is assisted by reference to whether or not Godwin was or wasn't rightly decided or decided at all. My Lord Sales.
Yes, thank you. I fully understand that it's the two stages to the analysis under Section 8. I'm a little bit unsure. Do you accept that at the first stage that one can have a conscientious belief that the state should honour and respect a loving relationship between same-sex partners in the same way as it does between a man and a woman, is something that falls within the scope of freedom of conscience as that concept is used in Section 8. I quite understand that there are difficult questions in relation to hindrance, but I was just wanted your submission as to the first stage.
My Lord, that is not, I think, well, I have to admit, that way of putting it has not been put to me in argument. Sorry, it's not been put by my learned friend in argument, and it's not something on which I would feel comfortable giving an answer without taking instructions, which is obviously not easy in present circumstances.
Right. Well, I rather understood that was the beliefs, set of beliefs that were identified by the Court of Appeal. I think it's paragraph 79. It links in with my previous question to you as to whether one shouldn't see the legal recognition in the context of the background reasons why one might want legal recognition. The thrust of your argument being that one focuses just on the legal recognition bit, and I'm seeking to put it to you that perhaps one looks at it more widely. I had rather understood that the way the courts below identified it put it more widely than pure legal recognition.
Lord, well, as I say, the argument that we have put to you is the way that the attorney understands the position, and that I don't think, as of now, I can take that further.
Well, are you able to venture an answer to my question, putting it in the way that I did, or you just don't want to?
Well, as I say, Lord, it's not a question of don't want to. It is a matter, obviously, when one is representing the attorney, me speaking off the cuff may not earn me favours or thanks, and answering that without instructions, I would feel uncomfortable doing.
Yes. Sorry, just to assist you, it's paragraph 57 of the Court of Appeal's judgment, page 449, if you wanted to look at that.
Yes. Yes. Sorry, that is. Yes, that is the definition of the beliefs as we understand the courts to have analysed.
Yeah,
all of them.
Yeah. So if you take the first one, it's a religious belief in marriage as an institution, and then recognised by law, which same-sex couples ought to be able to participate in.
Yeah.
So that seems to be putting the legal recognition in the context of the wider institution of marriage.
Yes, but it is sorry. Yes, but it is precisely because it is a belief as to what the civil law ought to be providing that we say it is not a protected belief under Section 8, because Section 8 is a matter of personal conscience, and in relation to matters which one can manifest through unilateral action of observance, teaching, and practice. And as to what the law ought to give you is not a matter of conscience, it's a matter of social policy, which is what Lee and Ashers tells us. And that is the dividing line between beliefs which are matters of conscience and political beliefs as to what the state ought to provide. And that is the conceptual. I don't know if by putting it that way I've answered your Lordship's question, but
I rather think you have, yes.
That's the conceptual divide that on which we seek to rely, my Lord.
Yes, thank you.
I'm very conscious of the time, and the only things I just wanted to do briefly in conclusion were really just to pick up that although, as we are only too well aware from the wealth of authority here, that same-sex marriage is something that has been grappled with from Hong Kong to South Africa to Canada, the learned friend has not identified a single case in any jurisdiction which has shoehorned a belief in same-sex marriage into Article 9 of the European Convention on Human Rights, Section 2A of the Canadian Charter, or any cognate provision. Now, he went through our Strasbourg case law, and he said, oh, well, yes, that was an ancillary point, it wasn't the main issue, and yes, Article 12 is the lex specialis, and so on. All of those points are individually perfectly true, but all they demonstrate is that Malone and Friend can nibble around the edges of a string of case law that demonstrates that repeatedly Strasbourg has said Article 9 doesn't embrace or include a belief in same-sex marriage as a protected belief. There is no case law to support this line of argument. And just in response, my Lord Reid asked me a question yesterday, which I said I'd come back to. I think in the course of my submissions, Your Lordship asked me if I was saying that this is apropos of ECHR case law applying in Bermuda. Your Lordship asked me if I was saying that the ECHR applies to Bermuda. I'm not sure if I was at cross purposes with Your Lordship, but you may recall I was drawing a distinction between the case of Lendor, which was dealing with Trinidad and Tobago, which had become independent, and in respect to which the UK was no longer responsible for its international relations. And I was saying, by contrast, Bermuda does remain a British overseas territory. The UK is responsible for its international relations, and the UK has extended its guarantee, the UK's guarantee, to Bermuda in relation to the ECHR. So the ECHR as itself hasn't been incorporated into the law of Bermuda, but the guarantees under the ECHR have been extended to Bermuda, to the territory of Bermuda, under whatever is Article 4 of Protocol 1 by the UK. And as a result of that, certain presumptions or working assumptions can arise that the executive or the legislature will act consistently with convention rights. It is the case that ECHR case law is not binding in Bermuda, but on points where it is relevant, it will be persuasive because the ECHR has been extended to Bermuda and because its constitution is closely modelled on the ECHR, as was pointed out in Fisher. The last few points I just wanted to deal with very rapidly. Pretty and the UK, the motor neuron disease case, illustrates very clearly that the question of what falls inside or outside Article 9 is not a question of how important is the belief, how central it is to one's identity, or anything of the sort. It is a question in our submission as to whether or not, and Pretty really does illustrate this, it's a question of whether or not the belief is a matter of conscience, i.e. what the person believes they holds important on the one hand, and what Diane Pretty was trying to do, which was to use Article 9 to demand action from the state by promising not to prosecute her husband if he helped her to die. And although the facts are very different, that conceptual divide between personal conscience, what one thinks and what one can do unilaterally, and demanding action from the state is very clearly illustrated by Pretty, and it's, in our submission, illustrative of the different outcome that should be arrived at in this case. My lords, my lady, I'm conscious that we have reached 4 o'clock, and I haven't answered my learned friend's points on Section 12, but I don't think I actually have anything new to say on section 12 that you don't already have. And unless there are any further points that you would wish me to address, I was going to wrap up there.
It looks as though you've given us plenty to think about, Mr. Crowe. Well, we're most grateful to all counsel for their submissions and their assistance in the preparation of submissions given to us by others. This is obviously an important question. We will be hearing argument also in the appeal from the Cayman Islands, which is a separate appeal raising different issues, but there is some overlap. And in due course, we will then decide what advice we shall humbly tender to Her Majesty. Thank you all very much. We will now adjourn.